So I'm working on a new book on the turn to arbitration and also mediation in the first half of the 20th century in the United States. I've studied the US and Europe for a long time and have been very focused on the differences between them. Arbitration seems to be the latest front of a kind of growing, or at least long-standing, transatlantic divide on the procedural side of things. So arbitration is a agreement between two parties that if a dispute arises between them, they will bring that dispute to privately selected arbitrators instead of to a public court of law. Historically, arbitration was most commonly used in the commercial context, where you had two businesses or two merchants of roughly equal power who fully negotiated their relationship, and as part of that relationship negotiated and enshrined in a contract, also included an arbitration provision agreeing to go to a private arbitrator if a dispute arises. What we've seen since the 1980s in the United States is the rise of a very different kind of arbitration, where corporations are putting arbitration provisions into contracts of adhesion, take it or leave it contracts, that they then have their employees or their consumers sign. So these are not negotiated contracts. These are contracts where the individual party often has no knowledge of the arbitration provision. There are many aspects of this that are troubling. One is the fact that this is not a negotiated transaction at all, and often the individuals signing or clicking on these agreements are not even aware that they've given up their day in court. Another is that the proceedings themselves are secret, so we have very little public check or knowledge on what's going on. And a third is that they're structured in ways that suggest that they may systematically disadvantage the individual employee or consumer as against the big, wealthy corporation. European countries have systematically, at the level of the European Union and at the nation-state level, have banned arbitration in the employee and consumer context precisely because of these concerns. So I've been interested in exploring the roots of how the US came to embrace arbitration.